Canada, the House of Commons Standing Committee on Justice and Human Rights. Pursuant to order adopted by the House on March 22nd, 2023, the committee is meeting in public to begin its study of Bills S-224, an act to amend the criminal code, trafficking in persons. Today's meeting is taking place in a hybrid format. Pursuant to the House Order of June 23rd, 2022, members are attending in person in the room and remotely using the Zoom application. Since our witness is a member, he already knows how to use the Zoom features and the interpretation features in the House, so I don't think there's anybody externally that does not know it, so I won't go into those. I would like to welcome Dr. Colin Carey, Member of Parliament from Oshawa and the sponsor of Bill S-224 for the first hour of our meeting. Welcome to the committee, Mr. Carey, and you have 5 minutes to present if you have opening remarks, and then we'll go to questions from members.
Thank you very much, Mr. Chair. Today I'll be speaking to Bill S-224, a nonpartisan bill which passed unanimously in the Senate on October the 6th, 2022. This bill had its start as Bill C-461, which I was honored to present in the House on June 17, 2019. Unfortunately, it did die on the order paper. I want to thank Senator Toulajan for taking up the cause and successfully stick-handling this through the Senate. I want to thank Arnold Viersen for his unending commitment to end human trafficking. I also want to thank an amazing community of supporters, victims, moms and dads, survivors, and many other stakeholders. I want to share an experience of a survivor I heard recently at a forum organized by the All-Party Parliamentary Group to End Modern Slavery and Human Trafficking. Alexandra spoke to us about her experience, saying, I walked into the commercial sex industry at 20 years old. I was an adult, over the age of consent, and able to make informed decisions for my own body. I believed that I was taking control of my sexuality by using it for personal gains. I never thought of my boyfriend as a pimp, and I certainly never considered my situation to be trafficking. It wasn't until 10 years after my experience that I was informed I was trafficked. This is the reality you need to understand. I made choices and I was manipulated. I believed I was consenting, empowered adult, and I was exploited by my boyfriend. Had the police intervened in Alexandra's situation under our current laws, it's unlikely her case would have fit what they look for, as it's focused on victims' mindset. She wasn't afraid. The purpose of the bill is to align Canada's law so it is consistent with international law, align with the Palermo Protocol, and properly places the focus on the actions of the trafficker, a protocol that we as a country ratified in 2002. It will facilitate convictions against those who participate in human trafficking in Canada by amending the Criminal Code's definition of exploitation and human trafficking offences, so the Crown is no longer required to prove a reasonable person in the victim's circumstances feared for their safety or the safety of someone they know. This will put the onus on the perpetrator rather than the survivors. Our current code reads as following: 279.04.1. For the purposes of Section 279.01 to 279.03, a person exploits another person if they cause them to provide or offer to provide labor or a service by engaging in conduct that, in all the circumstances, could reasonably be expected to cause the other person to believe that their safety or the safety of a person known to them would be threatened if they failed to provide or offer to provide the labor or service. In contrast to our definition, the Palermo Protocol views human trafficking as having 3 distinct elements: the act, the means, and the purpose. Human trafficking is defined as the act of recruiting, transporting, harboring, and receiving a person by means of coercion, abuse of power, or deception for the purpose of exploitation. This is not reflected in Canada's criminal code. Colleagues, we have a serious lack of convictions here in Canada. The latest statistics for Stats Canada are really compelling. It was released in May 2021 and show the serious challenge police face when trying to get a conviction, and it's only getting worse. When examining court decisions 2018-2019 by charge overall, the vast majority, 89% of human trafficking charges were stayed, withdrawn, dismissed, or discharged. Less than 1 in 10, 7% charges resulted in a guilty finding. Now, I want members to pause and to think about the situation in Canada for victims of human trafficking. A crime is committed. There's no debate whether or not the acts have occurred, yet under Canadian law, the victim is required to prove fear in order for a conviction to occur. So to emphasize the absurdity of the situation, let's apply this requirement to another crime. Imagine someone I know comes up and stabs me. How would I prove fear in that situation? Would the offender be convicted if there was proof of a crime but fear could not be proven? I ask you, why do we treat the crime of human trafficking so differently? Human trafficking is a scourge, mostly on vulnerable young people and their families across Canada. This overdue change is consistently brought up in conversations by stakeholders across the country and internationally. Vulnerable young people often think of their abusers as their friend, that their abuser cares for them, loves them. Often the Crown case depends on the victim's testimony, the only evidence against the trafficker. Without the victim's testimony, there is no case. In Canada, sometimes it takes years to come to court. There, the victims can be victimized again and again. Usually, a conviction is not obtained. The Palermo Protocol was adopted in November 2000. It has 117 signatories, including Canada, and more than 22 years have passed. Yet this small but important change is still not reflected in our criminal code. Human trafficking is on the rise. Traffickers seek out young people dealing with substance abuse, traumas, addictions, abuse, homelessness, women and girls, Indigenous children, new immigrants, persons living with disabilities, LGBTQ2+, and migrant workers are among the most at-risk groups. We need to give victims every tool possible to allow the return of their dignity, their humanity. Bill S-224 is another tool, and it is a long overdue change. Thank you, colleagues, and I look forward to your questions.
Thank you, Dr. Carey. Now we'll go to our first round of witnesses. The first round for 6 minutes, we'll go to Mr. Brock for 6 minutes.
Thank you, Chair, and welcome, Dr. Carey, to our Justice Committee. And thank you for the passion by which you stand behind this important proposed piece of legislation. I listened very carefully to what you said. All of the content was very informative. The biggest takeaway for me, and I guess the most startling aspect of what you had to share with us, is the statistics that actually exist. That notwithstanding the prevalence of this scourge that you've properly identified in society, it's a worldwide phenomenon, and Canada tends to be a hotbed of criminal activity, particularly in this area. Notwithstanding the prevalence and the popularity of this particular crime, unfortunately, the criminal justice system has failed too many victims, particularly vulnerable victims from marginalized communities, speaking of Indigenous women and girls and LGBTQ community members. So I think that this is an important step along that way of trying to address these wrongs. I know that as a prosecutor, I never really had the ability to prosecute a person charged with human trafficking per se. Inevitably, the police, recognizing the limitations by which prosecutors would be able to prove these offenses, would often look at other offenses in the criminal code to perhaps ease the burden by which prosecutors would face. So I'd like to hear your thoughts on this aspect, this particular question. I took some time to review Senator Tulujan's interventions in the Senate during one of the committee studies. And what stood out in my mind was her comments that, in her view, this would lead to a greater ability of prosecutors to be able to prove the case, that this would, in her view, tend to allow more victims to come forward without the element of fear, fear being proven in court. But also, she also mentioned that it would remove the burden of proof on the prosecutor and actually relay that or transfer that to the accused. So I have some concerns about the latter aspect, but I'd like to have your thoughts on the first two.
Thank you very much, Mr. Brock, and I really respect your experience. When you're looking, first I'd like to talk, you mentioned the statistics, and they're extremely troubling. Back in 2015, human trafficking, if you look at the latest StatsCan report, there were about 300 reported cases per 100,000. 2019, it's up to 500 reported cases. So that's a 40% increase in just 4 years. And we know because of COVID and all kinds of different things happening right now in our country, the numbers are just going up. So it's incredibly disturbing. You mentioned Senator Tulijan's comments in the Senate, and I thought she did a very good job. The reality is, where in the world do we have victims? Sometimes child victims. I think 25% of people being trafficked are under the age of 18, where they sometimes, quite often, depend on their trafficker for basic necessities in life, food, shelter, where they have to prove in a court of law that they actually feared their trafficker. So by changing this definition, this long overdue definition that, by the way, we decided 23 years ago to make this change, it gives an extra tool in the toolbox. It's certainly a very complicated issue. It's not going to be the be-all and end-all, but it's going to give another tool to prosecutors in order to enable more victims to come to court, because now this unfair burden of them having to prove that they feared the perpetrator, which in many cases, even the example I brought forward, just isn't the case.
Okay. Now, what do you say about the potential that this will enable more victims to come forward?
Okay.
What are your thoughts on that?
I think it's true. I think when we look at the reality out there in Canada, there's so many reasons why victims may not want to come forward. Other countries, for example, have more stringent sentencings and more clarity. If a young person in particular is being trafficked, just imagine the fear that they have going into court, the stigma. With the current definition, for example, it has the term reasonableness in it. And you being a lawyer, lawyers are very smart, they know the system. By having reasonableness into it, you can introduce things like, the stigmas that are surrounding human trafficking, other factors that can be put in there to cause doubt. Now, quite often, victims, they will recant what they've told. They live in fear of these traffickers, and they know the sentences too, that they're going to be out in a shorter period of time. So, this is not designed to be the be-all and end-all, but it will give another tool to get more people. Get the Crown prosecutors the ability to get more people into court and actually hopefully get more convictions.
And that's certainly very welcome. So thank you for the opportunity to ask you questions, Dr. Carey.
Thank you, Mr. Brock. We'll now go to Mr. Nackby for 6 minutes.
Thank you very much, Mr. Chair, and Mr. Carey. Thank you for being here today and talking about your bill. I wanted to start by getting some of your impressions and all the work you've done in putting together this bill around the question that we've often talked about in this committee. We did a study on sex workers as well as to how does one distinguish between somebody who's actively involved in sex work versus somebody who is being used to perform sexual work and may naively believe that their trafficker has their best interest in their mind. What have you found as you were working on this bill around that distinction, and what advice do you have for this community as to how to create that distinction as well?
Thank you very much for the question, because the distinction is incredibly important. When you're looking at prostitution and when you're looking at human trafficking, I think it's important to realize as well, human trafficking isn't just prostitution. There's, I think one of the biggest cases we had in Canada was workers who were brought over to this country, and then the traffickers were threatening the family back home, and we see that quite often. When you're dealing with human trafficking, the difference between that and prostitution would be that you need a third party in human trafficking. So in other words, somebody doesn't traffic themselves. I would be, for example, the human trafficker trafficking you to somebody else, and being able to have control of that situation. So prostitution in itself is not necessarily human trafficking, and I think it's important to make that distinction.
Is there a legal analysis or legal test that you would propose that creates that distinction?
I think it's already quite clear legally, the difference. As I said, in human trafficking and exploitation, and that when you're looking at that point of view, you need to have a third person involved. So when you're looking at sex work, and if you want to define sex work, and you speak to sex workers, that's a choice they're choosing in the example, my opening example of a young woman who entered sex work on her own volition. But when you have a third party involved, that's not necessarily that choice.
Your bill deals with a definition of exploitation. I take it as more being presented as a clarification around the definition. The current definition of exploitation in the criminal code focuses on the impact of the trafficker's conduct on a reasonable person in the situation of the victim, and the current definition has about 17 or so years of case law associated with it. Can you give this committee some thoughts on what do you think will happen to the existing case law as it relates to defining what exploitation is with the passage of Bill S-2224 if it passes?
You're correct. There's 17 years of case law, but I would argue that with the current definition, it really hasn't worked. If we're looking at a 7 or 8% conviction rate, something has to change. And I'm sure you're going to be having Department of Justice lawyers here, and I think they will discuss the case law. They may talk about recent case law in Ontario. I think the Sinclair case, it was 2020. In Quebec, there was case law, and they mentioned because of the case law, perhaps now you don't have to prove fear. However, I would argue to committee and to Canadians that a lot of this depends on the judge that you get. Now, we're all aware of that case in Alberta where a federal judge said to a victim, why couldn't you just keep your knees together? Okay, and I think all of us are offended by a comment like that. Whereas if we actually replace the definition with something that is internationally recognized, there's going to be clarity in that regard and an opportunity that we can move up that 8% conviction rate.
In your mind, what's the key difference between the definition or in the jurisprudence and the one that you have presented in this particular bill?
Well, the key difference is going to be that the onus now is going to be on the trafficker, his behavior, not the victim. Currently, in order to get a conviction, you have to prove fear. And in many cases of human trafficking, as I mentioned in the opening, the person being trafficked may not necessarily fear their trafficker. They may be convinced that it's a boyfriend or sometimes, sadly, a family member, somebody they rely on. And that, I think, is absurd. Why are we treating victims of human trafficking different? Again, I brought the absurd example of another crime being brought up. If I was stabbed, we wouldn't have to worry about any of that.
Great. Thank you very much. Thank you, Chair.
Thank you, Mr. Naqvi. Now we'll go to Monsieur Fortin for 6 minutes.
Merci, Monsieur.
Thank you, Chair. Good afternoon, Mr. Carey. Thank you for being here with us today. I've been listening to you for a while now, and your presentation does make sense. But I would like to know more about the reasonable apprehension of fear. We've had lots of discussions here in the committee dealing with trafficking, sex trade over the past few years. And to my great surprise, I knew nothing about this before. I learned that Amongst other things, there are women and men and people who decide to engage in prostitution, and they recruit a bodyguard, a driver, somebody who's responsible for their appointments, and they are coming here to ask us to preserve the right these people have to work within a certain structure so that they can work in more favorable conditions. We may be for or against, but these are representations that we had, and we were wondering, well, for as long as we agree, and if someone is the main actor, it should be allowed. Now you are removing that requirement that the person should have reasonable apprehension of fear. I'm bothered a bit. I wonder what the objective is. Let's take it that the person engaging in prostitution recruits, well, this is a hypothesis or theory, recruits somebody who takes appointments for them, and that person says you have to work Thursday evening from 7 to 10 p.m. Are we going to say that it's a form of intervention to engage in trafficking, whereas it's the person engaging in prostitution who has asked that person to take appointments for them? So this may not be really direct, but these are ideas that worry me. It's not something I really know well. It appears that the fact that the person being exploited has to testify that there was reasonable fear. That appears to be reasonable to me. Don't you think so?
First of all, Monsieur Fortin, merci beaucoup pour la question.
Thank you very much for your question.
I would suggest to you that someone who is participating in prostitution and hires someone for their business, that is one case where somebody selects that as a choice, and the people they would hire to make appointments, etc., is part of that a unique situation of choice. What I'm trying to get at with this particular bill, and I'll try to use the same analogy that you made. Let's assume for a moment that you imagine probably the worst human being you could ever imagine, somebody who lies, coerces, and he has recruited you, and he's done that through force. He's done that, and he's maybe provided you with heroin. He may have locked you up in your room and said, you know what, you're not even allowed to go to the washroom until you come out and agree to do what I need you to do today. I need you to make $1,000 for me. And you work under those situations for a number of years, and you become engaged with this individual who you may start thinking of him as a boyfriend. And then down the road, he says to you, you know what, I want you now to look after these other three in my business, and I want you to beat them. I want you to look after them, and it's your responsibility to make $1,000 per girl for me, or else, if that's the case, I'm going to beat you more. I'm going to perhaps not allow you, that puppy that I bought you, the one thing that you love, I'm going to kill your puppy. I'm going to go after your family, your brother, your sister. This is the difference. This is somebody who is criminally coercing and taking advantage of somebody, quite often somebody who's very young.
C'est un bon exemple, M. Carey, où là, vous nous parlez.
That's a very good example, Mr. Curry. You're talking about threats and violence, and we'll come back to that. But in such a situation, it appears to me that the victim would have no difficulty convincing a court that there is reasonable apprehension of fear. It's obvious in the example you've given. But if there's no fear, I'm somewhat disturbed. We don't have a lot of time. Let me come back to 279 1B. It says that violence, threats, fraud, abuse of power, abuse of trust are all things that are used. This is an exhaustive list. So you are adding any other similar act. And when I read that, let me come back to my previous question. What are the other similar acts that could cause somebody to be convicted? Because, once again, let me go back to my example before. Somebody who is a prostitute recruits a driver, recruits somebody responsible for appointments or for whatever, and that person says, listen, we're going to work this evening. Well, the person may say, you booked me for this evening, I have something else to do. And they say, you must come work. Does this become a similar act that leads the person who is engaging in prostitution? Well, I don't know. I feel like the net is too wide. I like the succinct part of your bill, but I think that the scope is kind of wide, and that's disturbing.
Mr. Fortin,
Thank
you bring
you,
up a very
Mr.
important.
Fortin.
Oh. Okay.
You're slightly out of time. We'll hopefully get some time again. Mr. Garrison for 6 minutes.
Let me start by allowing Mr. Carey to answer that question.
Thank you very much, Mr. Garrison. When you're looking at the actual definition, okay, so this is the criminal code and it's under human trafficking. So by definition, for the purpose of section 279.01 to 279.03, a person exploits another person if they engage in contact that causes the other person to provide or offer to provide labor or a service. So in other words, a third party situation, and involves, and you brought this up, and I think this is the point you were trying to make, involves in relation to any person the use or threatened use of force or another form of coercion, the use of deception or fraud, the abuse of a position of trust, power or authority, or any other similar act. And the concern is that's too broad. That wording was placed in the bill we captured the primary methods used by traffickers in the Palermo Protocol, but it's not exhaustive. And there are many methods that traffickers can use to maintain control over the victim. Further, including that last term, any similar act, it allows the legislation to be nimble and the courts to be able to stay consistent and with the constant evolving technologies that are out there, new methods used by traffickers to control their victims. With new technology out there, they're finding different ways. So that was the purpose of that. And if it was a situation of prostitution, it should not even be captured under this definition. Does that make sense, Mr. Garrison, to you, or did you?
So I do share some of Mr. Fortin's concern about the breadth of the definition in this bill. But I want to back up. I know it goes without saying, but I'm going to say it, that nobody here supports trafficking. But what I have most often heard, and I'm going to ask you about this, from law enforcement agencies is, yes, from some, that they'd like some changes in the criminal code, but most of them have said to me that they lack the resources they need to combat trafficking, that it's not a high enough priority given their limited resources to spend the funds on to actually combat the trafficking. And that's what I've heard from police, frontline police, as the major problem, and not necessarily the definitional problem in the criminal code.
And Mr. Garrison, thank you very much for that. And I also appreciate the fact that you're listening to police on the ground, because when I started engaging for this bill, that's exactly what I did. Talk what's happening on the ground. I believe what you said too is correct. The resources aren't there. Now, if you look at the reports in the last few years, the greatest reporting comes from Ontario, where I think there's 30% of the population, yet 60% of the reports, and Nova Scotia. Now, you're going to be having other witnesses here, and I would ask you to ask that question to them as well, because it's hard to actually prove, but I think, in some people's opinion, is the more money that they put into the resources to actually report it, now we're getting more reports. And the system, I know I spoke to Durham Regional Police Services in Oshawa, and I must applaud them, because even for a very low volume of resources, respectfully, they're doing a fantastic job. And I really commend the police, because in this situation, we now know, and you're aware of it, the victims quite often don't trust the police. They don't want to go to the police. So the idea is, what else in this very complicated issue of human trafficking can we do as a society to start to address some of these other issues that need to be reformed as well. But I do believe this is an excellent start. And when you look at stakeholders, even Alberta's strategy, point one, is to change the definition. The Americans write a report on different countries every year. They're asking Canada to come up with an international definition because, Mr. Garrison, as you know, this is not just a Canadian situation. It goes across many different borders.
Although I guess I would say that the international protocol was written more than 20 years ago when understanding of both sex work and exploitation and trafficking was a lot more limited than it is today. So I'm not exactly sure that that's a point in favor, is going back to something that was written 20-some years ago. But let me say the other group that I've talked to extensively, of course, is sex workers. And what they fear is the unintended consequences of expanding the definition of exploitation so that it takes away agency from those who, either from a positive choice or from circumstances they find themselves in, choose to engage in sex work and in doing so employ others to help them administer their business, keep them safe, and all kinds of other things. And when you say in this definition, any other similar act, they're worried that this will catch people who are not exploiting them but are working with them to make their work safer. How do you respond to the concern among the sex workers in Canada?
Well, first of all, they have legitimate questions, legitimate concerns, but I don't think they need to be concerned about this because, as I said, by definition, when you're having a choice, that's not something that's going to be covered in this change of definition.
But isn't that exactly what the concept of fear being involved guarantees? Is if the person has to be afraid, then it's not a choice. And when you take that concept of fear away, you've written a very broad definition of the activities that in many ways denies agency to those involved.
Well, my response to that would be when you're looking at human trafficking, as I said, you've got a third party involved, not the individual who's actually chosen by their free will to do this. And again, I use the example in my opening statement of a young woman who made certain decisions voluntarily. But then after a number of years, and if you look at her full testimony at that committee, which I'm sure could be made available to this committee, she found herself in a very difficult situation. And her case, under the current law, wouldn't have made the grade as far as getting prosecuted and convicted.
I know that without the
Thank
chair
you.
here, it's hard to see the card, so I'm out of time. We'll come around again.
All right, thank you, Mr. Garrison. Next, we'll go to Mr. Caputo for 5 minutes.
Great. Thank you, Mr. Chair. I'm just going to pick up where Mr. Garrison left off here, Dr. Carey, and perhaps what we're looking at when Mr. Garrison's talking about people who are making their choice and who this is intended to catch, I think the Hansard would reflect or should reflect that this is meant to capture relationships of exploitation. What do you say to that?
You're correct. This is not meant to be a broad net. It's a specific net. Human trafficking, as Mr. Garrison said, there's not anybody around this table that is going to be standing up in favor of human trafficking and exploitation. The challenge we're having in this country, Mr. Caputo, is we got a very, very low conviction rate. And it's not just one thing, it's a combination of things. And when one chooses to make a private member's bill, you make a choice, and as you learn about it, you learn that the issue that you brought up is much more complicated. However, if you listen to advocates on the ground, which I think this committee is going to have the privilege of hearing from different testimonies, I think you'll be you'll be satisfied that this bill is going to do what it claims to do.
Yes, I'm sure none of us around this table want to see another person trafficked, period. It is coercive behavior that really does strike at depriving a person of their dignity and their physical dignity, their sexual dignity, all sorts of different things. I think we would all agree that we never want to see any of that done. And if we talk about the conviction rates, Dr. Carey, I think it really goes hand in hand with the nature of the offense, which is that manipulation. It is the abuse of trust in a lot of cases. And typically, the only way to prove the case is going to be through the victim. There isn't going to be some other mechanism. So if the evidence isn't going to be coming from the victim, who themselves may have been manipulated, is almost always going to have been abused, and oftentimes is somebody who is otherwise marginalized. It doesn't surprise me that we see really low conviction rates. So I support certainly making legislation that would enable the courts to deal with what I think is really a plague that we underestimate in our society. Now, you had spoken about onus, and sometimes when we talk about onus in law, we talk about reverse onuses a lot. We're not to talk about that here, but you did mention onus, and I just want to be clear. This isn't a reverse onus in the legislation where it talks about I think you said the onus is on the accused behavior. And what I take you to mean in that case is we're looking at what the accused person does, not what the victim perceives. Is that accurate?
That would be an accurate statement, right?
Okay. So in this case, the Crown must prove beyond a reasonable doubt what the accused person has done, as opposed to what the victim perceived or would have reasonably perceived. So in this case, the Crown would have to prove the causation to provide or offer labor or a service. So they have to contribute to the person doing that. That's legal causation. And then there have to be some sort of threatened force or coercion or deception or fraud or abuse of position of trust, power of authority, or any similar act. And that's where we're talking about that exploitative element that you and I discussed at the beginning of our statement. But the burden, your intention is that the burden would be on the Crown to prove it rather than the accused to disprove that. Does that make sense?
Exactly, and I think that makes sense to everybody. When I mentioned in my opening statement, why do we treat human trafficking offenses different than other offenses? You know, if it was a straightforward crime, and I use the example of being stabbed or something like that, you wouldn't have to prove that in my mind at the time, there was fear, right? Because it's absurd.
Well, I know I've met with a survivor of human trafficking, and it had a profound impact on me. I'm not sure how much time I have left, but those were the thrust of my questions. Thank you.
Thank you, Mr. Caputo. We'll next go to Ms. Briard for 5 minutes.
Thank you, Mr. Speaker. Merci d'être avec nous.
Thank you for being here with us this afternoon for presentation of your bill. Bill S-224 deletes the interpretative clause referring to factors like threat, deception, or abuse of power that the court could consider to find out whether or not someone was exploited or whether there was an intent to exploit. We do have case law on that, particularly the Sinclair ruling that has been there for many years. The definition, the current definition was included in 2005. So we do have case law. What will happen to all that with your bill?
We'll be replacing what's on the book right now, and I may be wrong, but I think the Sinclair case was 2020, not that long ago. And again, what you're looking at, the federal government has a role to play here, and when the federal government advocates its role, you'll see provincial courts actually take a role. And it took until 2020. The courts are now saying that perhaps we don't have to prove fear, and the courts can interpret that the way that they want. Again, I'd like to bring up, it depends on who the judge is. Now, if we change it the way that I'm suggesting here, it's going to be very clear in federal law what we mean. There won't be that room for interpretation. It'll be a certainty. I brought up that case in Alberta where, the judge basically said, why couldn't you just keep your knees together? And some history, my original bill that I presented in the House actually mentioned that perhaps there should be training for judges to understand the intricacies in human trafficking. Now, that is not present in this bill. Again, the choice was made that in all likelihood, if we take a smaller piece, it's more likely to be able to get through the House. But there needs to be more education. There needs to be a whole other group of, I would say, factors that need to be taken into account in our country in order to help fight this scourge of human trafficking. This is one small step, but it'll make a huge difference.
Et justement, parlant de
Talking about factors, we know that Canada is an origin, transit, and destination country for men, women, and children who are victims of sexual trafficking. And it's also a destination for men and women who are subject to forced labor. Most cases where charges were laid in Canada are national cases, and this affects sexual exploitation. This means that it's mainly women and young girls who, in Canada, who are victims of trafficking for sexual commercial exploitation, and most of the perpetrators are men. How would this new draft of the definition take into account all these factors that make women and girls more vulnerable to trafficking? How does it also take into account more vulnerable populations like indigenous women and girls and the LGBTQ plus community as well?
There are different populations that are more susceptible to human trafficking if we look at the demographics. And if you're interested, there are different things through Statistics Canada to look at that. But you rightly pointed out, I think it's 85% of those who are trafficked are women and girls. 25% I think are under the age of 18. You also mentioned quite correctly that Canada is a destination for sexual exploitation. When I was originally looking at my original bill, I attended a round table at what was called UOIT in Oshawa. It's called Ontario Tech now, but it was a round table put on about human trafficking and exploitation. And at that round table, we had FBI and we had Texas Rangers there. And in Texas anyway, they have a different system where they have these mandatory minimums. So if somebody's caught in Texas trafficking 6 women, okay, he knows he's facing 60 years in jail. Most of the time, and the officer said to me, we get this guy to plead out in 3 months. He's in jail, he's off the street, good thing. He said, your system's crazy. He said, listening to these victims here, it may take 3 years or 2 years to get to court, and then they're re-victimized. And if you listen to some of these victims, your heart goes out to them because they're getting on with their life, they're changing it, and then suddenly they have to go back to court, and they may be faced because they're on trial. The attorney, the defense attorney, is going to make them the bad person. So this means that many of these cases will get dropped. So by changing the definition the way that I'm proposing here, it's going to take that onus that it's going to be about the perpetrator, the trafficker. It's not about proving that that victim had an element of fear before when the trafficking was occurring.
Thank you. Thank you, Ms. Briard. Now we'll go to Monsieur Fortin for 2.5 minutes.
Merci, Monsieur le Président.
Thank you, Chair. Mr. Carey. As I said a while ago, I would like us to specifically talk about how to determine exploitation. It's said that the person could threaten to use force, coercion, deception, fraud, abuse of position, abuse of trust, which I think is already broad enough. And to that, you also add any other similar acts. So, what do you understand by any other similar act?
Well, I was, I guess, trying to explain it a little bit earlier. What we have, there's a list, and you've read off the list that is actually in the bill, and these are the most common issues in the Palermo Protocol, but it's not an exhaustive list. There's a lot of other things going on, and with the...
J'essaie de...
I'm just trying to understand what it means.
It will allow the court to be nimble on any new, for example, I mentioned technologies that are brought in that would allow somebody, a trafficker, to coerce and intimidate a victim. I brought an example as well to you earlier on that there are all kinds of different ways that human traffickers coerce and intimidate their victims, some extremely horrible ways that they do that. So when you're looking at the technical question you asked me about this bill, it's almost impossible to list all of them. So the decision was made to come up with it is a term that could be interpreted then by the courts in a situation of human trafficking.
Mais quand même, c'est parce qu'on parle de...
We are talking about sending someone to jail here. Though I agree that we need to act against such criminals, I have no pity for anyone who abuses or who sells sexual services to someone else. They should be punished. But in our work as lawmakers, it would appear that we need to be stringent before we send someone to jail. We are talking about sending someone to jail, so we don't want to make mistakes. We've made a choice. We may agree or not, but as in our society, we are saying that it's better to have criminals in society than innocent people in jail. I think that's why we have the notion of presumption of innocence. So for as long as you are not convicted, well, you are not jailed. So our duty as lawmakers is to clearly define... Already?
Seconds over.
Wow, okay. So,
No problem. I know it's a short time. We'll go to Mr. Garrison for the final 2.5 minutes.
Thank you very much, Mr. Chair. When the bill was in the Senate, Professor Benedette from UBC Allard Law School suggested that if we were going to make this kind of amendment, perhaps there should be another element added. And she suggested adding abuse of a condition of vulnerability to that definition of exploitation. I wonder whether you were familiar with the proposal and what you thought of that proposal.
Yes, Professor Benedette, I'd like to thank her too for all the work that she's done as an expert witness in front of the House and the Senate, I think, in the past. She did bring in something that she thought should be added to the bill about the vulnerability, and this goes to what Mr. Fortin was saying as well, because it would now look at the victim. Why was that victim chosen? In other words, there's certain people out there that traffickers hunt down and are selective, and her interpretation would be that it should be reflected in the bill. My response to that, Mr. Garrison, would be what Mr. Fortin and I were talking about when it says any other similar act, I think would allow that to be incorporated. However, she does have a very good, strong opinion, and I hope perhaps if she is able to come to this committee, you could delve into that a little bit more about what she thinks about that. But I do think, in my viewpoint, that it would be handled with what we have there.
And I guess I know I'm going to run out of time very quickly here, but most of our examples that we've talked about are those which involve sexual trafficking and exploitation. But the bill, the existing law and the bill deals with a much broader question of exploitation of persons, including forced labor. And so I wonder whether the changes you're suggesting, again, broaden things so that all kinds of other practices, which we wouldn't normally think of as exploitation, might be brought under this bill if the definition was changed.
I don't think it is too broad, but you bring up, we have talked about sexual exploitation, but one of the I guess, biggest cases we had, I think it was called the Domator family case. And this is quite common if you're listening to stakeholders, and I was unaware of this. One witness mentioned that cleaning businesses in his area, there was a reason why the quote was so low for his office to be cleaned, because the people who came in the middle of the night were immigrants who knew immigrants, and maybe people that were in this country illegally, that were being abused and coerced and intimidated by someone, and that trafficker was threatening their families at home, that if they didn't do the work. So this will not just deal with sexual exploitation. The target is those people who unceremoniously take advantage of new immigrants, people in vulnerable situations, and that's the goal of the bill.
Thank you.
Thank you.
Thank you, Mr. Garrison. That concludes our first round, our first hour, and I want to thank Mr. Carey, Dr. Carey, for coming in today. We'll now suspend and reconnect with a new link, as I believe it's in camera, Mr. Clerk. Just nod if it's yes. Yes. Okay, so I'll be suspending, and those that are on Zoom members, please rejoin via the new link.